Of the people of Jamaica, haste in the footsteps of those who are coming. Give us wisdom, understanding as we proceed in your most humble name. Amen.
Thank you, Member Skeffrey. Next item, apologies for absence.
Senator Brown will be late. Lambert Brown, yes, he has at a meeting at the IDT.
I know Member Campbell has indicated that he's on his way, so he too will be late. Anybody else? So may we now proceed to item number 4, which is welcome and opening remarks. Yes. Let me welcome you again to this another sitting of our Joint Select Committee on Occupational Safety and Health. I see we have here today representatives from the Ministry of Health. As you recall, at the last meeting, which was last week, Monday, it was indicated that the deliberations may be better served if representatives from the Ministry of Health would join and be allowed to participate. So I am pleased today to see not just Mr. Warren, again, the president of the Employers Federation, who was with us last week, but also representatives from the Ministry of Health. I'm told that there are 3 representatives here, and I guess eventually you will introduce yourself and the capacity within which you operate. But I see Mrs. Jacqueline Bisesa, Senior Medical Officer. I'm told of Mr. Everton Baker. Could you just indicate? Yeah. Everton Baker and Mr. Richard Baker. Okay, so we welcome you to these proceedings. Yes. Okay. Oh, my apologies. Jacqueline Bisesa. Very well. I do stand corrected. So that's the Chief CMO. Yes. Yes, I know what, for the purposes of the record, yes, we have to ensure. But by way of background, team from the Ministry of Health and Wellness, as you know, the committee is considering the bill that was tabled in Parliament some time ago, the Occupational Safety and Health Bill. The records disclose that at the time of consultation, the Ministry of Health and Wellness did in fact participate in the consultation. However, by virtue of certain occurrences in recent times, the committee is further of the view that the participation of the Health and Wellness Ministry at this stage is important as we seek to put forward a bill that will capture the best bill we can put forward at this possible time. And as I've said before, it is felt that your input may very well help the committee in finalizing that bill that we know is going to be far-reaching as it will apply to all branches of economic activity. So we welcome you here. We invite you to participate. I do not know if you were given or you had an opportunity to review the bill as was laid on the laid in the House of Parliament. But notwithstanding, in your following the discussions that ensue hearing after, do feel free to indicate, should you so desire, to comment. Members, on the last occasion, we taken through, we're hearing from the Ministry of Labor as it brings us up to speed with this new policy document that they have put forward. Since then, they have sent us a further document which would have included some of the comments which would have come from the Attorney General's chambers. So I think the first document we had comprised of 8 pages, and now we see a document before us that comprises of 12-page document. My understanding is that it would contemplate certain modifications. I know that on the last occasion we had stopped at, based on the old document, we would have been on page 4 that looks at staffing of the authority and appointment of the executive director. I see now that they have amended, and I believe that, and I will hear from the ministry, I think we would be at item number 2.4, which deals with the appointment of the executive director and functions of that office. Yes, Soldier.
A slight increase in volume with the mask. Thanks.
Morning. Okay. So the chambers had comments on the functions of the authority that we didn't go through last meeting because we had to give the members the opportunity to voice their own concerns on the functions. I know that the ministry has done some adjustments. I'm just trying to understand how we'll proceed. Is it that we will not go back over the functions now and leave that until later? Because I noticed that you were going ahead at 2.4. And there have been some changes to functions and delegation.
Let me hear from you, Mrs. Bennett Campbell, then I'll hear from you, Member.
There are 2 aspects of functions that we would need to just go back over. We made 2 changes. One, as requested by, based on feedback from the Attorney General's chambers, and one in relation to the need to put public education campaign front and center. So we actually made, as far as I believe, it was 2 changes to the functions. 3 changes to the functions. So I would have liked to highlight those 3 changes.
Before you proceed.
Yes, and the Attorney General could have said her feedback in relation to it.
Member Gill, you wish to say something?
Sorry, Chair. Since the document has no track changes that would have made it easier, I recall the technical team would have indicated that they would have had some concerns, and maybe at some point in time, if it's feasible for those concerns to be pointed out, especially if in the area around the functions of the authority, since we had passed that. And then the Ministry of Labor can then therefore identify those other changes that would have been substituted or amended in the revised document.
Very well. So we will proceed by allowing the AGs to chambers to walk us through the concerns that they had in respect of the functions of the authority, and thereafter the ministry will pick up from there.
Thank you, Chairman. So the first issue we had with the functions was, the only issue we had with the functions was the one that is now at number 1, but it has been modified. So before it said monitoring and enforcing compliance with the Act. And then in parentheses, it said this includes investigating contraventions of the Act, initiating and giving instructions to conduct and defend proceedings, and issuing notices to secure compliance. We referred the ministry to a recent case in relation to powers of INDECOM and pointed out that you needed to be very clear and specific the types of powers you want this authority to exercise. Now, there, of course, are some differences with this proposed body and INDECOM in that this proposed body is supposed to be a body corporate and will have the powers to which Section 28 of the Interpretation Act applies. INDECOM didn't have that power. But in any case, if you want, so this body would have the power to be able to sue and be sued. However, if you wanted the investigative powers, it shouldn't be something where you have a general monitoring and enforcement of compliance. You needed to be very specific about the powers. So I note now that the ministry has amended number 1 to put investigating contraventions. However, there is no guidance on who will conduct prosecutions. And so we would need to know, because if we know the intention of the ministry, then we know what would need to go in and what would not need to go in. So under the Constitution, the DPP does not have the sole remit to initiate prosecutions. However, the DPP has the sole remit to take over and to discontinue. So normally, it would make sense if you're going to try and exercise a power to initiate prosecutions that you should really have discussions with the DPP, perhaps get a fiat. There are other stat bodies that have the power to initiate prosecutions. So one example would be the NSWMA. But again, you don't want these bodies to be exercising a power without consulting the DPP in light of the powers that DPP have and to take over or discontinue if they don't agree. But again, we would need to have an idea of who is supposed to be initiating prosecutions under the Act, and then would have to be able to, once we know that, we can guide the ministry as how best to achieve that matter. One other matter in which we would need clarity on is the authority is going to be carrying out investigations. And I know that the bill itself spoke about a tribunal. So for instance, if you have initiated investigations, there are some concerns. What happens after that? And I can't now recall of the decision whether we're going to retain that tribunal feature or not. But just a warning, the FTC had a power at one point in their act to investigate, and then they had the power to review the decision, and then they were also having the power to take a decision. So it's basically that they investigated, they were judging their own cause. They investigated, they reviewed the results of the investigation, then they took another decision, the results of that. And the court ruled that to be a contravention of the, in any case, we had to do an amendment, and what the scheme that they now have is to have an independent body to review. So it was a breach of natural justice principles, and you're not supposed to be a judge in your own cause. So I'm just raising that because whatever the scheme is, we always have to bear that in mind, that if the authority is going to carry out and perform investigation functions, then we have to be careful about the next steps thereafter to ensure that you have another independent body, whether the court or whether an administrative body that will then do reviews thereafter.
Very well.
Chair, recall yes. One of the fundamental reasons why we had suggested the route of a possible tribunal was where there was an aspect of the legislation that suggested that in case of sanctions to be imposed, there would have been sanctions relating to fines and so forth, which in our view would have taken possibly some extended period in order to resolve those issues. And so we had sought to suggest the way of utilizing a possible tribunal. But I can understand what the Solicitor General is suggesting in terms of function 1, the investigation, and also how you tie with function 14 that I had raised last time we met in terms of resolving the resolution of exercise of the rights to cease or to refuse to carry out unsafe work. Again, I agree with the fact that we can't have a situation where, as an authority, you become judge, jury, and executioner in the same trail. So, well, just using the term to heighten the issue. And this is where, Chair, it becomes a little bit complex in terms of the role and function of the authority.
Mrs. Bennett Campbell, I'll hear from you.
I will speak to the discussions we had, because we had a lot of discussions at the ministry about the power to prosecute. Now, we did not envision giving the authority the power to prosecute when we thought about it. We wanted to be nearer to what we do now, where they would have actually prepared demand letters, and they would have actually then liaised with the clerk of court DPP based on the criminal sanctions. So we were not going to give the authority, in our view, the power to prosecute when we thought about it, especially not at this stage. So we wanted to go through the normal way where they would instruct either the DPP or liaise with the clerk of courts. That is what we had in mind.
Yes, Member Campbell. Member Campbell, I'm told your mic is, yes.
I know that, Madam Soljan, there is, NEPA has a scheme under the various provisions that they have where they prosecute for breaches of their legislation. Do you know what scheme it is? Because I know, well, I recall very, very vaguely them having a scheme where they carry, but I think it's done in collaboration with the clerks.
So Section 36 of the NRCA Act provides as follows. The authority may, by instrument, in writing, authorize any such person as it thinks fit, hereinafter referred to as the authorized person, to institute proceedings against any person for an offense against this Act, and to recover any penalties under this Act or regulations made thereunder, and the authorized person may prosecute or conduct such proceedings. But this is not unique, because as I said, I think even NSWMA, there are a number of these stat bodies. And I know that issues had arisen about the capacity of clerk of courts and DPP, because it's more usually clerk of courts that you will get to assist you in these matters, especially before the parish court. And because of the capacity, and when I mean capacity, I mean just resources, the amount of work the clerk of courts will have, these types of matters will not have priority. They're not going to have priority over an assault and a wounding, any of those types of matters, and you have a plethora of those types of matters. So it has always been seen to be a little more efficient if some of these authorities have this power. So usually there is collaboration, but they will go ahead. I do know of a flip situation where a ministry, in trying to deal with breaches under, I think, the old Fishing Industry Act, as it was called, and related legislation, would have had issues because they didn't have this power. Well, they didn't have a stat body at the time, and so the government, the ministry would have had to go through clerk of courts, and they used to have challenges because, again, these are not matters that would have been prioritized. So like illegal fishing and seizure of the boats. Also the capacity now of the clerk of courts who are not necessarily trained in this aspect, that aspect of law. there would have been also those sort of capacity issues as well. So this is, I think it's something that the ministry should consider. But the ministry already is aware of a number of matters because they're already going through the clerk of courts. What the ministry should take into account or consider at this time is how well it's working and the fact that the matters that they have now will perhaps increase. With this new framework, you are likely to now have even further prosecutions because you're expanding the remit of this new body. And so if there are challenges already, then perhaps the ministry should really take that into account. But that's for the ministry to determine how well the process is working right now and whether any changes would be needed.
Mrs. Benny Campbell, you would have heard the discussions.
Minister, we would have to discuss this with the ministry's principal some more because our instructions were not to go into prosecution, so we'd have to bring back all the concerns to our principals. We could not make that decision here.
Yes.
And just to clarify, it wouldn't be the ministry doing the prosecutions, it would be the authority, the new body that is being established.
Very well. So in that regard, in respect of how prosecutions will be treated and the scheme to be adopted, the ministry will come back before our work is finished here as to the appropriate scheme.
I had another comment, and it was in relation to a matter that was raised by a few members, which was formerly number 10, certifying technical examiners, and it is now 11. I noticed that no change was really made. I had intended to do a little research and just have not been able to complete that research. I'm going to ask that the matter be revisited at the next meeting. I'll tell you my concern. When you certify, I agree with a position that was raised by, I can't recall, I think it was more than one member though, to give the power to certify and you don't have the power to deal with matters prior to certification may be an issue. I also don't know if they really should have the power to certify the examiners because it's usually the persons who carry out the course, do the testing, that usually have this power to certify. If you look at other pieces of legislation, that is usually the scheme. So I just wanted to do a little more research in that regard, and I'm just alerting the committee.
Very well. So we'll defer that for our next date. So may we now proceed? 2.4, Minister. I recognize you, Mrs. Dr. Bisesa.
Right. Good morning. Morning, Chair, and morning, everyone. Thank you for giving us the opportunity to be here. We're just having a look at this sheet of paper and just looking through the functions of the authority. And I just want to bring your attention to point number 4, where it says establishing systems for the recording and notification of occupational accidents, occupational diseases, dangerous occurrences, and commuting accidents. In the review of the bill itself, the Ministry of Health and Wellness thought that there was not enough referral to the ministry that does have the authority on health-related matters. And in particular, this system of notification, remember that we do have a national surveillance unit that is responsible for receiving notifications and for reporting to the public on diseases that occur within the country. And so I believe that there needs to be some referral to the Ministry of Health and Wellness and our notification system here. Also, in terms of point number 7, where it says conducting research, experiments, and demonstrations in relation to occupational safety and health. This can be done in collaboration with other persons and bodies. Again, in terms of research, where it relates to health matters, the Ministry of Health and Wellness is the authority on this matter as well, and I am not sure what is the body for approval where this is concerned. And again, I would ask for there to be reference in the appropriate areas to the Ministry of Health and Wellness.
Yes, Member Longmore.
Chairman, I just clearly would like to just express my gratitude for accommodating my suggestions. And thank you, Dr. Bisesa McKenzie and the rest of your team for being here. I think as is being demonstrated, it is a very critical role that you play. Thank you.
Mr. Mohan?
Good morning. Well, just to speak to point 4 that the CMO has referred, at our last sitting, I had mentioned that the factory's regulation 77 speaks to in situations where there are cases of illnesses that are believed to be due to the nature or process of other conditions at work, then we have a duty to notify the chief medical officer, who shall thereupon appoint a medical officer to investigate and report. So it was our intent, as how it is under the Factories Act, to have a mechanism similar in the regulations that when it touches on concerns matters of occupational illnesses or health, that information would have been passed on to the Ministry of Health through the CMO. In regards to point 7, there is for matters relating to research and experiments, I take the point that explicit reference can be made to the Ministry of Health as well in that regard.
Yes, Mrs. Celia Brown. Well, the question is whether or not we manifest this concern on the face of the bill. Okay. So the advice is that this be manifested on the face of the bill. So in that regard, the ministry will revert to the committee. Mrs. Benny Campbell, we now move to point 2.4.
Before we move on quickly, Chair, these are new documents. Are there any other changes based on what was discussed last week before we move on?
I'm going to highlight 2 more changes on the functions.
Yes.
So number 10, the committee had asked us to put on the face of the functions conducting public education programs about,
And you're working from this new document now?
I have to, yes.
Okay, very well.
We didn't track changes because apart from, we didn't get far last week, so it's really with functions. I just wanted to highlight the other 2 changes. Conducted public education programs about this act and matters related to occupational safety and health. The committee had been concerned that we had not expressly said that on the face of the functions. So we tried to insert that. In relation to number 16, we had formulated and developing a national policy on occupational safety and health in consultation with the minister. I remember the Solicitor General had suggested in consultation with stakeholders, so we tried to capture that. So those would have been the only other changes that would have been made to functions. Can I move to just one thing in 2.3?
Yes.
In 2.3, it's the third sentence. However, the authority may still continue to exercise or perform any of its functions that have been delegated. The Solicitor General had recommended that we put that on the face of the delegation, so we did that. So those are the changes we would have made to the parts that would have been considered by the committee previously. Can I go to 2.4?
Yes, you may now proceed.
No, there was something else? 1 second. She's talking to.
You may proceed.
All right, 2.4a. We tried to make more sub-paragraphs so it would be easier to follow based on recommendations. An executive director is to be appointed by the Board of Management, board, in consultation with the minister with responsibility for labor. The board is to determine the compensation of the ED in accordance with relevant, and we try to look at the corporate governance framework to try to be compliant with it, published by the GOJ. The board is to determine the compensation of the ED in accordance with relevant guidelines from the Ministry responsibility for the public service. The ED is to possess the requisite knowledge, skill, experience necessary for properly exercising his or her functions. The ED should be able to exercise competence, diligence, and sound judgment in fulfilling the mandate of the authority, and should not have been convicted of any offense involving fraud, dishonesty, and moral turpitude. What we did, the feedback we had gotten from the legal teams that we had not fleshed out enough, so we added more in relation to the ED. And we looked at the existing laws in relation to body corporates. B, the ED reports directly to the board through its chairperson and is accountable to the board for the performance of the authority. C, the following are the functions of the ED. Managing the day-to-day operations of the authority. 2, planning, directing, supervising, and coordinating the activities of the authority to ensure that the entity fulfills its functions. 3, developing and implementing programs, performance targets, service standards, and any other standards of the authority for approval by the board. 4, preparing and submitting for approval by the board corporate plans, operational plans, or any other plans in keeping with the proposed activities of the authority. 5, providing or facilitating the administrative support of the board and its committees, keeping the board informed of matters relevant to the management of the authority, and 7, performing any other functions necessary for the proper administration and management of the authority. There was also a gap. We did not address the issue of what is to happen if the ED is temporarily unable to perform his functions. So we tried to do this here. If the ED is unable to perform his functions as a result of illness, absence from Jamaica, or other sufficient cause, the ED, in consultation with the board, may appoint an employee of the authority to act as the ED until he or she is able to resume duties.
Yes, Mrs. Seeley Brown.
It will have to be the board who will be appointing that person to act chair, and just a minor correction, not the executive director himself.
Yes. Mrs. Malik.
But question here, though, along with that line, you're due to illness. Illness can be indefinite. So when you appoint, once you're appointed until or within a phase basis. I know in some existing act, for example, the Public Defender Act or the interim act for the ombudsman, there's a period, and then yes. But so do you want? So I'll ask that question in that context.
At this point, we did not say that ED is appointed for a specific period.
No, not the ED. You know, well, the ED is not appointed, but I mean the temporary person.
Right.
Let's be frank. You can in a position and due to illness you're out for a year. That's not unusual.
And in a number of more recent pieces of legislation, it's usually about a 3-month period, because it's considered that anything above that, then you perhaps are looking at a new permanent appointment.
Yes, Mrs. Seeley.
I think we need to review C3, because I don't think the ED will necessarily be developing and developing programs, performance targets, service standards. They may implement or they may approve certain standards from a particular, I think this should be done by the board and not the ED.
So,
And I'm still not sure if they would develop the standards or they would approve the standards of a particular industry once it's submitted to them for approval. I'm not sure about the developing of the standards.
so you are proposing a deletion of C3 or a modification?
I'm like, clarity and a modification,
Okay.
and giving that power to the board and not necessarily the executive director.
Okay, very well. Ministry?
Is the query about the developing or the implementing? The developing?
The developing
Okay.
component, yes.
All
Sorry,
right.
just for
Yes,
clarity.
we could take it out.
Just for clarity, Mrs. Seeley Brown. The
Yes.
developing would be in whose hands? Whose? Because
Industry.
normally
For development
it is the
standards.
organization
Right.
that does the development. The board approves. And then the implementation now goes back to the team, which would, in this case, would have been led by the executive director. It's just how it's written in terms of, because at the end of the day, an organization is going to mark based on its strategic objective, based on the mandate given, and how that mandate was crafted in the first place. So it's a question of how it's written and who has the level of accountability in that case.
Ministry?
Yes, where we had put developing the program's performance targets, and so we thought that the team at the authority under the leadership of the ED would have done that and then start the approval of the board, because I did not know if a board would be sitting down and trying to develop performance targets or so. I saw the board as more reviewing what has been done. So maybe it's not expressed correctly, but that is what I kind of had in mind.
Well, now that you represent it, I understand what you have in mind.
So, yes. So we will proceed with it as it's in its current form.
We will work with the drafter to redraft it to capture what is the true intent.
Very well.
These are not industry standards. These are standards of the authority.
Authority.
Okay.
Mhm. Try it again.
Oh, it's back. Yes, sorry about that.
Yes.
So, okay, in relation to we did look at the absence of the ED. We noticed some legislation spoke to being absent for 2 months, and then after that, the vacancy would have to be filled. We will go back to our principles. We were not comfortable with the 2 months because of maternity leave, looking at the longest maternity leave. So maybe if it's another period, maybe 3 months or more.
What I'm saying, even if you don't, if you're not seeking to fill the position, after 3 months, then you do a review and you can reappoint or appoint someone else if you do a performance evaluation, you're not satisfied. But when you leave it as is, then it means that the person is appointed indefinitely until the ED is back at work. So I'm not really saying that you must replace the ED. That's not my initial argument. You might lead to that. But I'm saying just to appoint indefinitely. The new norm, as I see in industry, even education system, when you appoint an acting principal, for example, is within a term and you have to have a new appointment form and so on. So you don't get that level of complacency. So it's still in that context. But I also want to ask about the term of appointment for the ED. What's the policy on that? I don't see anything here. It speaks about the qualification and the ministry appointing. But how long? What's the duration of the tenure in the initial stage? And reappointment and so on. So the policy doesn't speak to that also.
in the meantime, I
Yes.
just wanted for the record to clarify, if someone goes on maternity leave and a vacancy would not arise. Okay.
Yes.
Thanks for that, because on a vacation, you're on leave. So you naturally feel the position is not a illness that your illness is different from maternity leave.
They wake you up covered.
Your maternity leave, you're not ill.
That is, I don't know if that's what she meant. I think what I heard her say is some women may need a little longer time.
That's the point.
And so if it's not 2 months, then maybe we can go to 3 months. That is what I picked up.
That was my understanding.
Right.
Yes.
Why are we discussing this?
No,
No,
Yes.
maternity leave leaves no job vacant.
yes. Yes.
Yeah, this is not vacancy positions. This is to do with, that is coming later down. This is it. No. I'm at C underneath, and this is where your temporary. No, that's not where I am. Oh.
I think the only thing that we need to consider is that it is parental leave rather than maternity leave. So I think we should consider that scope, parental leave, parental, whether
Yes.
it be maternity or paternity. Exactly.
So there's a 2.4C and a 2.5C, and I think we are at 2.4C.
Yes, I was still at the
Yes.
temporary absence because of illness, or I haven't reached over to vacancy yet
Yes.
in my mind.
Good. Mm.
Or other sufficient cause, which could have been maternity leave or some kind of leave. Right.
Proceed.
Okay. So getting back to it, we did not have a time in terms of the ED. We had the ED being appointed until removed unless the person is removed under 2.5. So I'm hearing a no
You
already.
can't have that, man. You're taking a step back, man. Retrograde step. When you give a person that high level of security of tenure, right? No, man. In every employment, man, you're given a fixed limit. Yeah, even Parliament, maximum 5 years.
But I was going to clarify, so the
Yes.
ED will not be on a contract?
You will have to be.
No,
Yes.
but no, couldn't be. But you don't have indefinite contracts.
Yeah.
What you say? Whilst chair, I'm one who prefers full-time employment and promote that. I've seen where other legislations of what I've spoken to a 5-year tenure. I've seen data protection speak to 7 years. But I would suggest that you define a period.
The ministry will definitely come back to the committee on that point.
I know we had the board being in place for 3 years, so we
Yes.
look back at that
We
to
were
see
guided,
where-
yes.
Sorry, one thing with the board appointments, will you have a staggering of board appointments? It's come up as an issue with another authority where all the board members
It's under
complete.
2.8.
Oh, okay.
So we will
Okay,
look at it
okay.
when we get there, yes. But I think we're at 2.5 now, removal.
So we consulted other legislation to see the circumstances under which equivalent person to an ED would be removed. Executive director can be removed from office by the board. This is 2.5. In consultation with the minister in the following circumstances: become incapable of satisfactorily discharging the functions of his or her office, is bankrupt, is convicted of any offense involving dishonesty or moral turpitude, fails without reasonable excuse to carry out the functions conferred on this authority, is proven to have brought the disrepute to the authority through misconduct. Now, the legislation also have a mental component to the removal. We're trying to figure out the best way to navigate that, because in terms of how to put it in, We don't want discrimination on the grounds of disability.
Outside of point 1?
Yes. I know I've seen unsound mind.
I'll suggest another amendment to number 4. So you have fails without reasonable excuse. It's usually to carry out functions conferred or imposed. In MOCA, there was also an addition to that provision to say that the person would have failed without reasonable excuse to perform the requirements specified in the contract of employment or the annual plan or whatever plans that you have. So if you're going to have an annual plan. So that's for consideration.
Okay. But we act on your advice in that regard, yes.
We were just following the route by which, because the person would have been appointed in consultation with the minister. So we were trying to see if removal, if you go back that same way. If you say it's not necessary, then we wouldn't. But that's why we put, understanding why we had put it in.
Members,
regarding...
You have destroyed...
Oh. No, you. Oh.
Solgen, the one you spoke of about becoming incapable of satisfactorily discharging the functions of his or her office, are you including in it the question of strategic, not being able to meet strategic targets? Are you twinning that?
Yes, so I'm just pointing out that that was a construct in the MOCA Act, where it twinned, it said, fails without reasonable excuse to carry out any of the functions conferred or imposed on him under this act or requirements specified in his contract of employment.
Oh,
or
just making it more specific and detailed.
Yes, because there have been issues about persons not performing, so it's not necessarily a function. You see, I guess it would, in the end, be deemed to be failing to perform a function under the Act. But the thing is, the contract usually has some very specific targets in there that may not be expressed as functions in the Act. And there have been concerns in the past. And so that was one of the modifications that we made to that Act at the time.
The only challenge I have with that, Chair, is that that might be specific in nature, but might not have been the full accountability of the individual. Whilst the individual is leading, there may have been other associated challenges faced outside of that, his or her authority, to render them from meeting those specific targets. So to put that into the legislation might be a little bit onerous on the individual as a standalone.
Yes, Member Longmore.
Thanks, Chair. I just wanted to address Mrs. Bennis Campbell's concern regarding the incapacity. You could just say that the person is deemed unable or is unable to function, to carry out the functions necessary, secondary to incapacity by ill health, whether physically or mentally. And that way you're not discriminated.
So that would be a modification of point 1 you're proposing?
2, 3,
Or
A1?
2.5A1.
Yes. Yes. And I'm just curious, this is just my curiosity here. Being bankrupt, is that across the board? Is that, I'm just wondering.
Not only is it across the board, some legislation, so now we say a bankrupt within the meaning of the Insolvency Act, and sometimes some go further to say not just a bankrupt or also include an insolvent. But going that, for some, it's usually seen as you don't have to go that far to include the insolvent, but normally a bankrupt, because there can be some attendant issues with bankruptcy.
Yes, Member Skeffrey.
I also want to be clear about the issue of the consulting the minister. What was the rationale and the way forward?
I think she gave an explanation.
No, I didn't.
Okay.
Reinforce my one, man.
Yes.
Yes. What happened when we looked at the corporate governance framework, you appoint the ED, the board, in consultation with the minister. So we thought if you were removing the person, you would take the same. So you're still removing, but in consultation with the minister who you would have consulted when you were appointing the person in the first place. So that is why we had framed it like that, in that is the way the person was appointed. So we thought you would follow the same route to remove the person.
So I haven't heard the concern. What's the recommendation?
But based on what based on what the drafters have guided, if it's not necessary for me to do that, then in terms of the removal, I wouldn't do that.
Very well. Yes, that's the point. So they're going to delete in consultation with the minister, on advice of the drafters. Okay, fine. So the position is that the drafters will advise us at a date to come. So we defer on that part. Mrs. Bennett Campbell, in terms of item 1 and 4 under 2.5a, you would have heard the suggestion as put forward by Solgen, and you would have heard Member Gill's reply in that regard. Also, Member Longmore, in terms of the ED's ability to discharge his functions by virtue of a mental condition, had proposed an amendment to point 1. Do you have any comment in relation to those two matters?
Yes, we will look back because, as I said, we wanted to put in the lack of mental capacity, but not in a way that is discriminatory under the Disabilities Act. So we were trying to find a way to put it in. I know that it's always put in, but we are under more pressure.
I understand the desire not to be discriminatory, but I mean, and the health persons are here. There are clear definition that defines that. So if we act in accordance with definition, unless the current definition is discriminatory, which we can be guided, but if it is not,
So
then we have no problem.
Normally, remember, it is linked to
Yes.
being an incapacity within the meaning of the Mental Health Act. So it could be that there is an issue with the Mental Health Act. I don't know.
And this is why my suggestion is that we move away from stigmatizing and alienating the mental incapacity to it being a health incapacity, which can be physical or mental. And I think that is the safest way to cover all bases, because someone can also be incapacitated physically. And we don't need to make that distinction here. The fact is that it's a health reason. A health reason is a health reason.
Mr. Chair, if I may add,
Yes.
I do believe the Disabilities Act makes it pretty clear, and there is the mental capacity that would be included, if you choose to include it, is not one that is related to a disability. Under the Disabilities Act, it refers to an intellectual impairment, which is a totally different thing from a mental disorder. The mental incapacity that would be included here, the person removed, is a mental disorder. So the person is actually incapable of doing that job. That is really the health issue, not so much an intellectual impairment.
Intellectual disability is just one form of mental disability. That is just one form, and the Disabilities Act is wider than that. But what I'll do, I will just liaise with the JCPD, because I know there were some concerns raised in the past. I'll just look at the language and see how we can best fit it. Because I know they had some problems with language with some of these legislation.
So you will get back to the committee in that regard. In respect of item 4, it's the same 2.5A4. Mrs. Bennett Campbell.
We will look back at that because we had looked at the contract of employment in the MOCA. So we'll just look at it just to make sure that, I don't remember the reason why we had not gone that route, but by the time hearing it, it looks like a route we should go, but I have to look at the implications. But the only thing we were saying though, which I would like to bring to your attention, any such removal must be carried out in conformity with any applicable laws, because what we're concerned about is the due process. This removal of this ED, especially in relation to 4, can lead to actually a matter before the Industrial Disputes Tribunal in terms of unjustifiable dismissal. So we did not see it on the face of other legislation, but I don't know if it's implied, but if you were just removed without due process, then that would be a problem, and this authority could find itself at the IDT in relation to unjustifiable dismissal in relation to this ED.
Yeah. Normally we don't
Yes,
put in
Sergeant.
things about natural justice principles because they always apply.
Yeah.
So we don't usually put in any sentence to say that those principles apply because they have to and they do apply. So
You got duly
the reason you
guided.
wouldn't see it in other laws.
Duly guided. Member Gill, you, as we clarified, all right.
Okay, but there is the labor relations code, but anyway, I will leave.
Yes, we're guided. We may now move on to B. Yes, 2.5B.
All right, so I'll remove that part. The executive director may resign his or her office by instrument in writing addressed to the Board of Management. The resignation will take effect from the date on which the board received the instrument or the date specified in the instrument, whichever is earlier. So vacancy now, which was C.
There's a question on that. I know the norm is that though a person can resign suddenly, but that's for good order. You tend to ensure that those who are employed are given that you within a month or a notice for just due order. I know that's what is a practice in some organization. So why would we want to take effect the same? So I give you Monday and then Tuesday I'm out and then you're left in limbo as an organization. It might happen, but why not say a due month's notice for good order? Or
the employee is not entitled to the same.
Right. You should have specified.
well, the context, you see, is, well, I guess you are reviewing that section because you didn't have that initial in the policy. So in that context, if you're not going to review the tenure, which you didn't have, so you didn't have a fixed tenure, So you didn't have a contract initially. So this would be in contradiction to even that.
No.
No, yes.
You see,
But I'm saying however we can structure it for good order. Sure, no employer, and we have David is here and you could say you don't want no employee to surprise you as an employer in the private sector. Though it may happen. So let us treat the public sector with the same level of order. So our law must so structure to let employees know that there's some responsibility even if you are vacating. Though it might happen suddenly and you have to live with it. But if we keep it in a general way, then the employer will not believe that there's a sense of responsibility also. I know, for example, I speak again from experience as in the education regulation. If you are employed, well, contract can be guided, but you have to give some notice. So I just believe, so I'm speaking that in a general term. Based on the terms of employment and the union persons are here best to advise, then how can we get that within the terms of employment?
Yes. Member Gill, before I come to you, Mrs. Sealy Brown.
the issue with that, Senator Skeffrey, is that those things are normally reduced in writing in the contract. And if you seek to put it here where the separation is on the part of the employee, then you may want to consider to put it in 2.5 in terms of the separation on the part of the employer.
I have no problem with that.
But the tidier way normally is not to have it involved in the legislation itself, but into the contract between the employer and the employee in the first instance.
No, I'm not. If I'm clear that in the policy, then those will be in the contract, then I have no problem. But the policy as you have here speak to an immediate effect. Hence my concern.
Well, it says immediate effect, it says the board received the instrument or the date specified in the instrument, whichever is earlier.
Okay, man.
So it gives you twofold.
Thanks for the clarity.
Depending on the employee.
No, thanks for the clarity.
Mrs. Seeley Brown, you.
I would delete from, I think it can stop at saying that he may resign by instrument in writing addressed to the Board of Management, and the other things that you can put
So
in
you
the
would
contract.
delete the second sentence? Okay. Minister?
Minister, will be guided because we had been silent on the issue before, but we did see that it's an issue that was dealt with in other
Very well.
legislation, like similar legislation. So
we deleting that
no,
second
they're
sentence?
resigning this part with the ED. Yeah.
In other legislation, this provision is put in usually for like board members where you have an authority where they're not contract employees. We wouldn't put this in if you are a contract employee because this should be dealt with in the contract, not in the law. If you've seen it in other laws, it must be for persons who are not on contract.
Very well. So we will be guided by Mrs. Seeley Brown's recommendation and remove that second sentence. Minister?
Vacancy. C. Where a vacancy arises in the office of ED, a suitable person may be appointed to act until the vacancy is filled. The acting ED is to be appointed by the, so this is in the same manner as the original ED would have been appointed. The acting ED is to be appointed by the Board of Management in consultation with the minister, and then it must possess the same skills that the ED would have had. All right, 2.6.
I don't know, before you reach 2.6, we're going to appoint an acting ED, but where in the policy will speak to a specific time frame to advertise the post and do recruitment for the ED. So you're going to have an acting, yes, but indefinitely. So I don't, where would that be? If not in the policy, where?
That would have to be a part of the policies of the authority in terms of how they do it. It would be hard for us to regulate exactly in the legislation how quickly you must do an ad and all those parameters.
Okay. That's my concern though.
Any comment, Ms. Seeley Brown? Okay, fine. So we proceed as is. 2.6.
Right. Employment of staff. The authority is to employ such staff as it thinks necessary for the proper carrying out of its functions. The ED is to consult with the board to determine the qualification for each post within the authority. The authority staff are to be paid remuneration and are to be employed on terms and conditions that the authority determines is necessary for the purposes of the Act. However, if you're going to pay salary in excess of any prescribed rate, you have to have the minister responsibility for the public service has to give approval. Upon receiving the approval of the minister responsible for public service, the authority may enter into arrangements for its employees or cause arrangements to be made in relation to schemes such as insurance policies, medical benefits, pensions, gratuities, and other retirement benefits, disability or death benefits.
Member Gill.
The ED is to consult with the board to determine the qualification for each post within the authority. Why we want to extend that responsibility to the reach of the board? A clerical officer, an administrative assistant. Why is the board required, in this case, to be consulted to determine the qualification? This is too wide.
Well, what it was envisioned is that the board could have oversight of what is being done in relation to the post and what is being paid, and that the right post has been described and the responsibility is more of an oversight than anything else.
This is suggesting, that you must consult with the board to determine the qualification for each post. I mean, that requirement is a management prerogative.
Member Campbell?
in the public service, don't we have these scales which have been set and assigned to the posts which are determined by the Ministry of Public Service? So all that would have been done prior to the establishment of the unit, the authority. And so that no consultation is not required in those circumstances. The posts, they're established and they're on the, yes.
Soldier, you wanted to? Yes. Member Ferguson, yes? Yes, okay.
Keep a little distance. Yeah. No, what I'm saying, that there are some positions that the board would have some say, because I know there are, within the framework of some boards as established in the public sector, there are different committees like Human Resource Committee, etc., that would look at certain levels of employment. But I do believe that it couldn't be all employment. There must be some level, some cutoff where that would be a function of management. But I could understand if there is a hierarchical structure, then there are positions that would definitely, in my mind, require some oversight. Because we have seen in the past where, in spite of what we are reading in this policy, that the persons are employed at salaries higher than that which is even accepted in the overall policy structure. So there must be some safeguards, but you can't take it that wide in terms of levels.
Yes, Member Campbell.
There is certainly, what we'll be talking about then are temporary employees. But if you have an establishment, those positions would have been predetermined as to what qualifications attached to them and the emoluments and all of that. So if we're looking at anything else, it would be outside what is contained in the establishment. But I don't know that to continue a debate over it is going to advance the matter at all. I'm just looking at a structure. We have 25 people on this structure, and we have ED and whatever it is. So in those circumstances, it has already been determined by the public service body that these, and if you want an amendment, if you want to escalate the numbers, then you certainly have to go back and to the ministry to have a new establishment set up, as it were. So, sure.
Yes. Mrs. Bennett Campbell.
Yes, I must be pointing out, though, that this is going to be a body corporate. It's not a ministry within the government anymore. So I'm not sure about the establishment and the post on the establishment. Yes.
I suspect that notwithstanding, the structure would have had to be approved.
But I know the Ministry of Finance would have to have approved any salary paid. But I will be guided that the provision is too wide in relation to getting the board involved in the qualification for each post. I think that is, I've taken what Member Gale has said there. That is way too wide.
Very well. May we now proceed to point 2.7 if there are no other issues? Transitional.
All right. Transition of Industrial Safety Division staff to USH Authority. On the appointed day, employees of the Industrial Safety Division within the Ministry responsibility for labor may be transferred on secondment to the services of the authority for a period of 6 months, or such longer period as may be agreed by the Permanent Secretary of the Ministry and the Executive Director. During this period of secondment, the employee is to be employed on such terms and conditions as may be determined by the authority. However, these terms and conditions are not to be less favorable than those enjoyed by the employee in their substantive position within the ministry on the appointed day. An employee who is transferred on secondment may be deployed in public service on or before the expiry of the period of secondment.
Could you use it back, Mrs. Celia Brown? Yes. Yes.
No, but why? Why you? No, I hear you, but isn't there a reason for doing this? Shouldn't there be other words to the effect that if he decides that he wants to be deployed back to the public service, why do you put him in for 6 months? Why is that provision? What is the mischief of putting that there?
It's just trying to have a transition period between the old ISD factories.
Like normally, I remember when we do some, we just say they shall become an officer of employees of whatever, unless they choose to remain.
It's the option that you're saying.
Yeah, the option. That's yeah. Is that what you're getting at when you speak to the period of 6 months?
And the last line would allow for deployment.
The problem is that, okay, what we have been discussing at the ministry is that we have the ISD division now within the ministry, and that is where our OSH inspectors, but we have secretaries, we have had, Mr. Mon can more speak to his staff complement there, right? So what happens is that some persons may still remain in the ministry. Some of these posts may be abolished because, for example, we may not need inspectors in the same way. We'll need some staff to help the ministry to be able to actually administer the act in relation to the ministry and making sure that they are compliant as the parent ministry, right? So some persons may stay within the ministry if there's a position there. Some people may have to be deployed into the wider public service. Some persons may choose to be going on to the authority.
Yeah. I think we need to flesh this out some more. We are talking about people who are employed in the ministry now under contract or some level of security or tenure. Just to say that you transfer for a period of 6 months and secondment and for a longer period, it has implication for pensions, for example. So, and other benefits that you may have. What will happen after the 6 months? Because you establish a new authority, they will have their new establishment. So, and they will have to advertise and so on. So is it that we're going to make those positions now in the Ministry of Labour redundant? We don't want to come up front and say it, but you have to speak to this committee as to what the intentions are. Because if you establish a new authority, you can't bound that authority to accept these employees unless the notion about doing your own recruitment makes little or no sense. Because it's not a total transfer. It's a new authority independent of the ministry. And if I'm an ED in a new authority, then you can just chuck your employees on me. So the ministry has to settle the dilemma that it will face. And in other words, if it's no longer necessary in the ministry, then those positions have to be made redundant, right, Union man? So no, I'm just speaking generally. Doesn't say that has to be the end game, you know. But it has implication for the workers. A person as a officer for 25, 30 years, but still don't reach 60 and on the verge of what will happen when these things come in. And if I'm the ED and I say I do appraisal thing and I look at it and say I don't want John Brown, what happens to John Brown? So I think as a policy we have to be more specific as to what the intentions are and what do we hope to achieve in the interest of the workers. And I know how bigger union many here will speak greater to that. But I asked that question last week. And we say we didn't reach there. But we reach here now. It can't be just for a longer period. A secondment, at the end of the secondment, where do I go back to? And that's what a secondment is, you know. I leave job by substantive post in the Ministry of Health and take a post somewhere in the public service. I take a 2-year secondment. At the end of 2 years, I love where I was. So I go back. So I don't know if we can really have a secondment here. Secondment from where? Because these posts are no longer available in the Ministry of Labor. Because you establish a new authority. So I don't know if secondment is even correct. Because if I say at the end of 6 months, I don't like where I'm at this new authority. Where do I go back to? There's nothing in the Ministry of Labor for me to go back. So although secondment is something we have to, it sounds good for the employer, but it can't be secondment. Not the right word, because if at the end of the 6 months, I don't like where I am now, I can't go back to the Ministry of Labor because there's no job there for me, because you have made those posts quote unquote redundant. And secondment is where I want some time to see if I love where I'm going. I don't resign, you know. Right?
And it presupposes that the post is
it remains, because it's still my job, you know. Somebody who's going to do that job now can only act until my secondment completes. So even in the policy, secondment can't be the terminology. Because you are creating a new authority. And I have nowhere to go back. So I need clarity, Mr. Chair.
Member Gill?
Senator Skeffrey is a big union man. I never said that part. But here's a challenge now. First of all, I have a difficulty in appreciating, in the first instance, this 6 months. I form the assumption that the authority may not be in a position to acquire the certain skill sets that may be available in the Ministry of Labor right now. And so that is why you are having this migration of skill sets into the authority under the guise of secondment. Under the guise of secondment. But there comes a time when that individual, that period of secondment will expire. And so there has to be the protection of the substantive post in the Ministry of Labor. Because upon the expiration of the secondment, it's either you extend the period of secondment or the individual will return to the substantive post. And if I was an employee being asked to be placed on secondment to the authority, I would first want to be guaranteed that my substantive role is protected and preserved.
I would not go.
No, I can understand, you know, because herein lies the challenge. The role of the USH officers are not roles that you can pick up off a shop shelf. Yeah? So in this case, what is being sought is a migration of those skills to the authority. And you expect and anticipate that the authority will then harness skills as we go along. But for you to have this question of 6 months and there is no definitive period of the secondment, or whether or not you provide the option for the employees at the ministry to be able to apply for these posts, and these posts are done in such a way that it protects the services of the employees. And here's a bigger union man in size. So those would have been my initial concerns with how the layout and intent of this particular transition is being suggested or recommended.
Sergeant, yes.
So perhaps I can clarify. I know not much is said here and a lot more detail is required and needed, but I'll just give you an idea of what has happened in some other entities that had some of these frameworks. I think I know that the ministry would have taken some of this from some transitional provisions from other laws, but sometimes what is written down in the transitional provision does not capture the entire process, as well as it was also specific to those entities, so you will need to know what you're going to do. So I'm going to give you 2 examples, for instance. What happened with TAJ, Integrity Commission, the staff that came from Contractor General, and even JIPO, so 3. And the general scheme was that the officers that were working in one entity, whether government, well, government for the most part, Contractor General is really a Commission of Parliament, so that was a little different, but the others were government, going over into a stat body. The process was that there was a initial secondment period, and that was to allow that new entity to recruit their staff. But because these persons were specifically trained, it was recognized that a lot of the staff of the new entity would have to come from, so like the government body that was dealing with things before. So TAJ as an example, you would have had TAJ as a department of the Ministry of Finance. A lot of the officers there are very specifically trained in the area. You don't have a lot of that expertise just generally out there. So it was understood and intended that you would try to populate the new entity with most of the staff, and I say most of because there could have been now some separation for different reasons. But persons would have been given the option to either try to move over to the new entity or remain in government, not necessarily now in the entity, in the government department, because that government department would no longer exist after a while. But we needed to have a transition period. It was picked as 6 months or such longer period. It's always 6 months or such longer period. It never happens in the 6 months, never does, because there's just too much to do. Now, if you elect to try and go over into the new entity, you're also advised. You have to apply for that job. So with all these entities, even JIPO, they all had to still go through a process of interview, a selection process. And not everybody even was successful. Most people, but not everybody. But that is what would happen in that period of 6 months or such longer period. And during that period, the persons were considered or deemed under law to be seconded. The other persons would have then been reabsorbed into government, if possible. Now, things have changed since some of those laws were done. Things meaning the Pensions Public Service Act, which now provides that if the post is abolished, it's no longer considered a ground of retirement. Instead, it means that you now fall under the provisions of the Employment Termination Redundancy Payments Act. So prior to Pensions Public Service Act coming into effect, if the post was abolished, the person would have been treated as retired on the ground that the post was abolished, but that's no longer the case. So the ETRP Act was amended to apply to government, especially because of this situation. So I'm just saying these are a number of factors now that should be taken into consideration in determining the best way to transition the employees. You have to do something. How you're going to transition them has to take into account the nature of the work, whether you know you can easily and readily find persons to fill those posts, because you have to consider that. You have to have persons that can fill the posts. How you move them over, things like pension rights, all their entitlements as a government employee, what happens with those entitlements, even when they are moved over, all of those matters have to be considered and have to be factored. And all of those matters also have a money aspect to it. There's a financial aspect to it that must be reconciled as well.
Welcome.
My apologies for lateness.
Yes.
I'm sure my colleague.
An apology was duly tendered on your behalf.
Chairman, I just come, but I'm understanding that this transition provision, and just listening to the subject, would be best accomplished by the process of consultation. In other words, the Jamaica Civil Service Association, the Ministry of Labor, the officers in the division could fashion the procedure and the way, and it be adapted, and they would have benefited from the consultation that took place. Since my friend Senator Gale mentioned my arrival, this is what the unions do himself in Sugar or other places where these transitions are taking place. Work through the detail and present us with a position which says this is how the transition is going to take place in law, but to have benefited from the consultative process, which is key to resolving matters of industrial relations. So I'd hope that they'll take that approach, meet with the JCSA and the officials, and work it through and present us with that transition. Having regard for all that the Solgen has said, that they experience and so forth. But this is something that they can work out, and we put that in the legislation.
Member Ferguson, yes.
Are we saying that what has happened in the other institution, that there is no model? Because what I'm thinking, Chair, is it that every time we have a movement like this, you will have to go through the kind of consultation being recommended by Member Lambert, or is it that our experience have now taken us where there is a workable model? I'm talking in principle, because I can understand workers will always have concerns about their what is it that they are going to lose in those circumstances, and what is it that they have to gain and take some of these decisions, and especially where you have this high level of expertise in an organization. It is clear to me that you need to have a mechanism that will allow for this kind of transition. And we are seeing more and more of this kind of model emerging. Oftentimes, these authorities might even have a higher pay scale than what they would have received in the government service. But at the same time, we also want to know that their years of service, what happens in these circumstances to your years of service. That I think is crucial for a lot of persons.
Well, my understanding of what the Solicitor General has said is that based on other cases in which a similar transition has taken place, this model has shown to work. So I would have heard from Lambert Brown, and I believe that consultation, because consultation is very important. Throughout all of this, I believe that there has to be some discussions. But I think what is before us and what has been recommended is that this model has worked. Solgen, you perhaps.
Right. So again, the law doesn't always indicate what happens behind the scenes. So in every single situation, there had to be consultation. The existing employees, sorry? Well, I was advised for the ones that I was involved in that there had been consultations and that there was general agreement in utilizing the model. So for the ones I know of, there was, and yes, there ought to be. That is best practice, because you want to have buy-in for your process. There was something else I was going to say, but I'm having a senior moment.
One of the things you want to be assured in this situation is that it's the most seamless transition possible, because it's not a situation where it calls for voluntarism in the transition. The authority is going to require these sets of skills, and you may have a situation where, because of this need to transition, the roles at the Ministry of Labor and those who play support may no longer exist. And so these are things that must be discussed to remove that freedom of, allow for that freedom of fear in the minds of the workers in terms of their future. And so these are things that, why Member Brown is suggesting that the consultation, even at the interface with the workers, must exist.
Yes, Mr. Warren.
Yeah, thank you, Chairman. I just wanted to add to the examples of TAJ and JIPO that were mentioned as to some of the precedents for this kind of process. Because I remember when the Deposit Insurance Corporation was formed out of the Bank of Jamaica and the Special Economic Zone Authority formed out of JAMPRO and MICAF, there must be some things that we can look at to make this process not one from scratch all over again. Thank you.
Very well.
Sorry.
Yes, Sergeant.
I do recall what I was going to say now, and it's in relation to entitlements. So normally, the persons who move to the new entity, there's always going to be a provision that speaks about them now joining a new, having new pension benefits. So usually there is a settlement of, like, you're paid up whatever you would have been owed from government, or, well, in relation to the Pensions Public Service Act, I don't think you get it now, but that would be, at least it would be finalized. You would know what your position is, and then you're supposed to start a new pension fund, for instance. These are things that you have to have discussions on. It's not, and you have to have consultation on matters such as some of their entitlements going forward before we know what to put in the law. And then normally out of it, then we can know how to craft all these different provisions that are there.
Very well. Mrs. Madden Campbell.
Minister, we will have to refer to our principals in relation to this issue. We'll bring to them all the concerns that were raised.
Yes, I think the Sergeant has guided us, and I think what I'm picking up is a general acceptance from the committee. I know the whole process of consultation has been raised, and the need to ensure that there is broad-based consultation as we seek to achieve this transition. So I think what I'm picking up is that there's a general acceptance based on the advice of the Solicitor General. So you may proceed to 2.8.
Mr. Mahoney is going to come in now.
2.8 Board of Management. A Board of Management of the Authority is to be established. This board is the governing body of the Authority, which should be responsible for the determination of the policy and general administration of the affairs of the Authority. The board is responsible for the development of the policies and strategies of the Authority. B. The functions of the board include monitoring the administrative operations of the Authority, ensuring that the Authority manages its funds prudently, performing any action necessary for the purpose of carrying out its functions. C. The Minister with responsibility for labor may give the board general directions as to the policy to be followed by the board. D. The board is to be constituted as follows: no less than 9 and no more than 15 members who are to be appointed by the Minister and the Executive Director of the Authority, who is to be an ex officio member. E. The appointed members of the board are to include the following persons at a minimum: at least one person selected by the Minister from a list of nominees supplied to him by organizations representing employers. At least one person selected by the minister from a list of nominees supplied to him by organizations representing workers. One senior officer or employee of the ministry responsible for labor who is nominated by the permanent secretary of that ministry. One senior officer or employee of the ministry with responsibility for industry and commerce who is nominated by the permanent secretary of that ministry. One senior officer or employee of the ministry with responsibility for health who is nominated by the permanent secretary of that ministry. At least one person who is an attorney at law who is admitted to practice in Jamaica and who is in good standing with the body that governs the profession. At least one person with knowledge and experience in occupational safety and health. At least one person with knowledge or experience in finance, accounts, and/or audit. The composition of the board will be keeping with policies of the government of Jamaica in relation to diversity.
Mr. Chair, may I? Yeah, there are a number of observations. First of all, the maximum number of persons that can be appointed, 15, minimum 9. But as I count, there are only 8 clearly defined appointees. So, and then we have a general provision. No, it's a, well, at least, okay, well, yeah, but yes. So at least one. So, you know, the one person selected by the minister from the list of nominees from the employers, one selected from a list of nominees from the workers. I am not comfortable with that. If you have trade unions, for example, and employers, why they give a set of nominees and then the minister select that one? What will be the criteria to so determine? So if you have the Confederation of Trade Unions, let's say one from the Confed, for example, and if they say Senator Gill must be the representative, then I don't think the minister can say I don't want Senator Gill. So if I nominate 5, the employers nominate 5, and then the minister solely will determine, okay, from this 5, this is the one I want. I think if you want to empower these bodies on the board with true autonomy, then let them name their representatives. I know, for example, again, in the Teacher Service Commission, JTA has a position there, and JTA named their rep, and the minister can say, I don't want John Brown and Mary Jane. They might don't like John Brown and Mary Jane, but they come in here to represent. So I think these bodies, just like how you have one officer or employee of the Minister of Labour nominated by the permanent secretary. He didn't say a list off by the PS and the minister selects. So I think the employers and the trade unions must name their rep. And to all others that falls in that line. You have the attorney at law, and I don't know what special skill set he or she must have. Just 5 years and so on. I mean, in a critical board like this. Then, what do you mean by in relation to diversity? Race, color, class, size, weight. What determines the diversification here? Right? So that's too general. I know. I can understand intent, but I don't think as a policy it can be left at that. But I fundamentally don't believe that the minister should select from a list of nominees for these critical bodies. And gender diversification. So what do you mean by that? But fundamental point I have, no list of nominees to select. The board, this is we're setting up an authority that must have the best level of independence. Sure, the minister is ultimately in charge. I respect that. But if you leave every critical appointment, because even the ones coming from the ministry is the minister. And we have joined up government, so it's still the minister. So you could have a board that is the minister's board, not just in terms of formality, but the minister really control. You don't want that in this context.
Mr. One?
Yeah, thank you, Chairman.
Right. Thank you, Chair.
I must commend Member Skeffrey for taking that position, because the precedent for how this is laid out in this proposed act is there for how the Industrial Disputes Tribunal members are selected. It is almost identical. And so we have always said to the ministry, we'll put forward 2 or 3 members who we think are, and you select one because that's what we're asked to do. And sometimes we put forward members' names that we think would be a good IDT rep, and we are told we can't accept this one. So I agree with that position. We, employers and unions and all the other interests should name their representative to make it truly independent. And that's how I'd like to see the IDT nominees be selected also. Thank you, Chairman.
Yes, Soldier.
So, Chairman, so we had also raised it as an issue. And then we had wanted more clarity if the ministry was deciding to go along with this list of nominees and how many persons on the list, how do you determine who you select? And I don't think it's a very good approach. It's not an approach that we have in many other laws. If you want to have a truly independent set of members on a board. We also had a concern with the fact that the criteria to select persons was only limited to, I think it's 8 of 15. What's the criteria for the other 7? Normally, it's included in an act also to help to guide the minister in a reasonable way. We didn't put this in our comments, but I just have to ask, do you really think that a 15-member board can get any work done? No. It's just a question. Seems very big from my perspective if you want to have a working board, a board to take decisions and a board. It seems very big for me. And the reason I'm also raising it is you've already named 8. I mean, I think, though, that there should be a representative from the disabled community, and there should be a representative for persons dealing with children's interests, especially when I'm thinking about, well, what we can put in terms of gender is there is a provision that we can ask for a sort of gender balance on because it can work either way. There are some that, some places are heavy on the male, and you can have it the other way. So normally we can put in a provision for that. But I do think there should be specific representation for the disabled community and those someone who represents the interests of children. But you would still have quite a number of persons that are not specifically represented, and I'm just wondering why it would need to be so big.
I'll take the representative from the Ministry of Health and Wellness.
Yes, Chairman. Thank you very much. Just similar comments under E with number 7 and 8. It's referred to the knowledge and experience. Is it that we want to have at least a certain level of knowledge and experience in this regard, whether postgraduate? So we have some benchmark, because experience can be just about any experience.
Chair. Yes, Member Brown.
No, go ahead, Joe.
All right. Member Cuthbert.
In regards to the Attorney General, should we put in maybe practicing for a number of years also? I think that the Attorney
That's on
Attorney
point
law.
6?
Yeah.
Yes. That's it.
I also have I thought it was not there, but it's still there. This thing about who is in good standing, we don't usually put this in. So, for instance, you could pick, right, and I'm not sure even what you mean by good standing. So public servants don't need to have a practicing certificate. And if the good standing is referring to that, then I'm not in good standing. I don't have a practicing certificate because I don't practice outside of government. And I'm allowed to, under the Legal Profession Act, to practice as a government attorney without having a practicing certificate. So I would personally take issue with who is in good standing with the body. And yes, I mean, you could put a qualification of say, no, usually 10 years is a qualification for an attorney to be on the Supreme Court bench, 7 years as a parish court, on the parish court. So I mean, you could use that as a benchmark to decide what number of years you'd want the attorney at law to be practicing. Because you'd want someone who has, you want someone who has some experience.
Yes, Member Ferguson.
When we say the question, Solicitor General, in relation to good standing, are we saying, in your case, you would not have a license? But I think what is being contemplated there are persons, even with practicing certificate, who have, by virtue of past experience and how they have treated with their clients, might not be fit and proper, in my mind, for an appointment on a board such as this. But they do have a practicing certificate. So I don't know if the good standing is just in relation to a practicing certificate.
And I can respond to say that what you are referring to is fit and proper criteria, which should be applicable not just for the attorney at law, but for everybody on the board. And so what they should have are criteria for fit and proper criteria.
Chairman.
Yes, Member Brown.
Firstly, I want to deal with the size. The cabinet consists of probably 19 or so. I don't think my good friend would say of any other cabinets that they have not been functioning and serving. Right, former cabinet member, nobody would say because the cabinet is 18 or 19. It may be, but 18 or 19, the cabinet have always functioned and takes decision. Just take into account the legislations we pass in the parliament. All start and come through the cabinet. So when it comes to the size, what is important is the leadership of the size. I have sat on at least 2 government boards that have been fairly successful, that have had large numbers of members. And so it's not the size of the board. It is the effectiveness of those who serve on the board. And also it is important that because the need for diversity and the different views contending and informing, that a board of this size is needed. So I support that. In terms of the attorney, think of a case of somebody who has spent a long time in health and safety, but became an attorney and would come to the board even after 1 year of practice with some skills that would be beneficial to the committee. Why would we lock such a person out? Sorry? Not necessarily. You get both. That's why the majority voted for Hillary. They're going to get both. Just going to get she and Bill. But I think we shouldn't be too restrictive. Say an attorney at law admitted to practice. It gives the discretion to the chairman to find someone with 10 years, 5 years, or we might have one with 3-year practice, but who certainly has dedicated time and skills to an area that would benefit the committee. So I wouldn't be wanting to put too much restriction on that. But I agree with Senator Gale and the Employers Federation President in as far as the organization should be allowed to name their representative to the board. That's deepening our democracy. I won't comment on the IDT because what I know, Mr. Wan, is that some smart organization simply send a list with one name. And when it's rejected, resend the list with one name. Because that's who you want. And at some point, we will relent. So I'm not going to jump on the IDT now because so much people jumping on it. I see, Chairman, I see even foreigners jumping on the IDT and saying things about it. Well, about our labor laws that they don't even know. I think everybody here who follow the system know that village resorts never went to the Privy Council, but they are pronouncing that it went. The views might have gone there in another case. But if you're going to speak about our labor laws, at least show some respect for the facts.
Chairman.
Member Gill, yes.
I notice Senator Brown has agreed with me, and I have not yet spoken on this particular item. It's a good thing. But
you can't say you disagree.
No. But again, I just want to re-emphasize the point in terms of 1 and 2, where we have the selection of nominees. Because in selecting the nominees, these organizations would want to put forward that person who has the requisite, who they believe have the requisite skills and experience to represent the organization. And so it is the organization that must have that prerogative. Because these persons are going to not only to represent the organization, but also to report back to the organization. And so you don't want a situation where any minister would want to decide who that person ought to be. The second thing that I'd want, I just want to have some understanding in terms of 4. Why a senior officer or employee from the Ministry of Responsibility for Industry and Commerce, outside of maybe any other ministry? Because in my understanding, this piece of legislation is seeking to represent the widest cross-section, any and every specific industry. But why single out the Ministry of Industry and Commerce? Is there any particular reason or guideline?
Mr. Mahon, before you come in, I'll just take the... Yes, but I will still take your... And then now the ministry will deal with them in order. And I see Dr. Bisesa, her hand.
With respect to the size of the board and being 15, and then going further where it requires 5 for quorum, I was wondering in terms of decision making, and because that's only 1/3 of the right. So there's that, and then also as a reflection of that, in terms of final decision making, especially comes on to financial matters, what would be required for such majority to be recognized? Is it a percentage majority, et cetera, et cetera? Thanks.
Dr. Bisesa?
Okay, thank you, Chair. One of the main reasons why we're here today is that we wanted to express the representation of the Ministry of Health. and Wellness. And we particularly had wanted to comment on the composition of the Advisory Council and the Technical Advisory Committee, which now we see is being replaced by a board. So we would want to make sure, because the Minister of Health and Wellness still has the authority to make regulations for occupational health and safety, and also for the prevention of infection among all. And we would want to ensure that there is adequate representation and to prevent any kind of duplication of work so that we know what each other is doing. So you have a representation on the board, but then for the Technical Advisory Committee, the recommendation is that the Technical Advisory Committee be a subcommittee of the Board of Management. And usually, in my experience, I may be wrong, the subcommittees usually comprise persons on the board. So I would want to ensure that there is an opportunity, because we do have an occupational health and safety unit within the Ministry of Health and Wellness. We do have a Director of Environmental Health. And we would want to ensure that these persons have the opportunity to contribute at both levels, at the Technical Advisory Committee and also at the Board of Management. And so I know people are speaking that the board is too small, but I would hope that there is opportunity for more representation of the Ministry of Health and Wellness, seeing that it's very, very key and important role in these matters.
Item G14, page 10. I do not know if that will assist you in respect of the last point you're making, in terms of the Technical Advisory Committee.
Okay. And just recognize also that there is a position for someone nominated by the ministry on the board itself.
Yes.
Yeah.
Yes. All right, Ministry, you can now respond to the. Before you come in, Ministry, let me hear from. You wanted to say something, or you have to? Member Brown, yes.
Yeah.
Yes.
I just want to. I didn't see the PS until you called her name. Welcome, Madam PS.
I was corrected earlier. She's the CMO.
Sorry, CMO. Sorry. But am I understanding that health would not be satisfied with its representation as currently is, and you think that given the fact that health still has some responsibility for these issues, there should be more integration of the Ministry of Health within this? Well, let me, sorry, you want to say something? Well, let me ask, maybe the wrong person I'm asking because you're not the PS, but this bill would have been passed through the Ministry of Health before it got to us. How much did the Ministry of Health took recognition of it and thereby contribute to its to fashioning what it has become?
Yes, Dr.
Sure. Right. So this bill has been around for a long time, and I cannot answer how much contribution the Ministry of Health and Wellness has made. However, in our discussion of the present document that we have, we do not have a problem with the scope of the Ministry of Labor and Social Security in its ability to carry out the functions here. Our position is that the aspects of public health that comes under the Public Health Act will remain with the Ministry of Health and Wellness, but certainly in terms of the mitigation of risk associated with a particular occupation and the provisions of the workplace to deal with those risks associated with the occupation, we don't have a problem with the act coming under the Ministry of Labor and Social Security. However, as I said before, there needs to be definite representation of the ministry and more reference to the ministry in the act to say that where there are matters of significance, particularly in areas of infectious hazards, that there should be reference to the Ministry of Health and Wellness. And we didn't see that in the bill, that kind of reference to the Ministry of Health and Wellness, and we would ask for that. So in terms of we believe that we can see where the Ministry of Labor and Social Security is going in terms of it's taking on the mandate to ensure that the workplace is safe. But as I said, the reference to us for matters that are going to be of public health concern, especially when we talk about infectious hazards, is important. With regards to our ability to make regulations for occupational safety and health, I know a lot of persons are concerned now about especially biological hazards in the context of COVID. And so our workplace policies that we would develop with regards to infection prevention and control, we would be looking to putting those forth eventually as regulations under the Public Health Act.
Mr. Chairman, just want to, I guess, respond a little bit to Senator Brown's comment and also to Dr. McKenzie. I think we all are recognizing the fact and the importance of having a Minister of Health and Wellness represented. And as I said, I'm very glad that we are now at this point. It was a big deficit for myself, and I'm glad that we have incorporated such. So let us move forward. In moving forward, I think it is imperative of you, Dr. Bisesa McKenzie, to review as thoroughly as you can. I, in my capacity, tried my best to keep away of the specific interests of health and, of course, my particular predisposition to the mental aspects of it. I think because of our recent experience, I think you are also heightened to infectious disease, but still maintain the overall health objective. And also in the capacity of changing times. It's also the health risk with respect to the virtual world that we also need to keep abreast of as we document our way going forward in the future. So I would suggest strongly, and whatever support you may need, I hope you'll be afforded it, that you have a good briefing review of the work that we have done so far, which has been quite a lot, but bearing in mind that open health objective that you may very well serve. Thank you.
Member Ferguson.
I would strongly support the appeal from Dr. McKenzie, because the Ministry of Health, and I don't think we'd have to elaborate, its role, even in the period of what we have been experiencing over the last decade or so, and the impact on workers and places of work. And it is always a strong relationship between the ministry and the Ministry of Labor in these situation, I would strongly support our position in relation to having them on this, represented on this board. And the Public Health Act, a lot of persons don't come to realize how powerful an instrument. Now the risk management has come and has taken over a number of areas that public health would normally. But it's a powerful act which I believe having representation there would bring value to this piece of legislation. So I really would support it. Right, and the idea. So I'm just threatening.
Mic is on. Yes, I will just ask Dr. Bisesa Mackenzie for one final comment, as she has indicated, before I turn over to the ministry.
Right. So we do recognize that there is the provision for a representative from the Ministry of Health. So what I'm asking for, in light, persons are talking about the size of the board, I would ask for more representation, considering the different areas of the ministry that deals with this matter. And I would also, which somebody had clarified in 14, that we be represented separately in the Technical Advisory Committee.
Very well. Minister?
Thank you, Chair. I'll try my best to answer all the concerns, but let me start by saying that in putting together this policy position, that at the ministry we consulted 3 documents: the revised Corporate Governance Framework 2012, the Policy Guidelines for Nomination, Selection and Appointment of the Board of Public Bodies 2018, the Competency Profile Instrument for the Boards of Public Bodies 2017. And these are the government's policy documents. They can be accessed on the Ministry of Finance and the Public Service website. So in terms of the board, the numbers, Member Skeffrey had a concern about the selection of the representatives from the unions and the employers. Just to correct you, it was not it is at least 1 member. So in terms of the numbers of 9 to 15, it is really to give some level of flexibility as it relates to the increase in the numbers. The actual 9 is the ex officio member, the executive director that would have been added to meet that number 9. As it relates to the list, the Corporate Governance Framework for Public Bodies document on page 34 sets out under point 10 that where stakeholder representatives to the board are features of a particular statute, or where the minister seeks to include same, there should be multiple nominations to the relevant authority by the stakeholder organizations, from which the most suitable candidate may be selected based on the needs of the public body at the particular time. So we have heard the concerns of the members, but just to let them be aware that we were actually using this document, this policy document, to have this provision where we had said that there should be a list that would have been submitted for the members to be appointed. In terms of Mr. Baker's comment about qualification experience, their competency profile instrument document actually sets out the guidelines as to what are the competencies that would be required. It also mentions the inclusivity that the Solgen has been speaking about the gender balance. You know, the representation should be no less than 30%. I'm just calling from memory when I read that provision. So these documents would have guided, you know, how we, on the face of even setting out how these members are, to even try to ensure that we have the gender balances and so forth in the nomination and appointment of these, well, sorry, the appointment of these members after they have been selected for the board. In terms of Member Gale's point about why we have mentioned the Ministry of Industry and Commerce, we wanted to capture as great as possible representation from a ministry that has far and wide reach as it relates to not just manufacturing, because I remember manufacturing was one of the things we had before, but even the service industry, agriculture. So that is why we had looked and considered that the Ministry of Industry and Commerce would be able to capture a wider representation of these sectors. We were also concerned about the size of the board, so we wanted it to be as efficient as possible in recommending the members, the named members for the board. In relation to Member Longmore's comment about the quorum, these 5 members, this should have been changed because this is really too small. So we will revisit and come up with a number that is more representative of the quorum. In terms of Dr. Bisesa's comments about the representation of the Ministry of Health and Wellness on the face of the bill, we had agreed to take on the suggestion by Office of the Chief Parliamentary Counsel that instead of having it in regulations, that we would move it to the face of the bill. In recognition of the Ministry of Health and the technical competencies that exist, as we all have to work together in the whole business of safety and health in the workplace, for the Technical Advisory Committee, which would be now a subcommittee, because the fact that we were proceeding with this entity being a department and the Ministry of Labor and the policy has changed, we had to do some changes as it relates to the Advisory Council and the Technical Advisory Committee. But 14 would have covered that. We want to ensure that there is a member of the board who is chairing this subcommittee, but it makes mention that the technical expertise and qualifications would be considered to have that representative for the various work that these subcommittees will be undergoing. We had also mentioned earlier in the document about one of the roles of the board is for the formation of MOUs. And it is known that this legislation will not be replacing or trying to supersede some of the other regulations that exist out there that touch on concern and overlap of matters relating to safety and health. So it is through these MOUs, through the establishment of these subcommittees where we would have representation from not just technical experts, but members who have the expertise that reside within ministries, departments, and agencies throughout government, to have them impacting the output of these committees in a way that is positive to the work of the authority. In relation to the comments about the legal standing, the attorney, I'll just hand over to Ms. Benny Campbell to speak on that.
Yes, we were at first going to delete, but then we thought we should discuss what we had in mind. Because what we had in mind is, of course, not wanting somebody who may have been disbarred, may have multiple issues pending at the JLC. We did see it but we were not thinking about necessarily practice certificates alone in relation to like the government attorneys. We did see it in the information technology that they did have this similar wording. So that is why we had actually retained it, because we had it without realizing that it was actually in a legislation. But if it's a problem, it's not something we will argue over.
There's a quick point. The point I made about the appointment from the employers and the union, you said as against at least, but that's not the fundamental issue. It's a principle, and I don't know what the position is on the principle, that whether it is one or two, then it must be the employer and the trade unions, in my mind, to send the representatives or a representative based on what will be decided. So I still stand by the principle that the minister ought not to be the one to select from a group of. But when you send your representative, you represent the workers, the employers, and you are to support and accept that person, whatever the issues you may have, once they fall within the fit and proper criteria.
Yes, Mr. Simmons. Try your mic now.
Yes, thank you, Mr. Chair. The point I'd like to make really is with reference to as Member Gale had asked, why do you have a senior officer from the Ministry with responsibility for industry and commerce? I've heard explanation from the Ministry of Labour, but the very reason you're giving as to why you put that person there is actually why I think it should not be there. I think it's too broad. You read and truly, when you're going to have a minimum number of members of the board, you actually are trying to identify the particular individual that you want there. If it is that you want to capture the various industries that come under industry and commerce, then I think those need to be specifically named. And I also think that industry and commerce, while we have such a ministry, from my recollection, and you can check it for yourselves, but for half the time since independence, Jamaica has not, in fact, had a Ministry of Industry and Commerce. So it will be very difficult, I think, going forward in the future to even name such a representative to this board. You've had various formulations over the years: trade and industry, trade, industry and tourism, commerce and consumer affairs, social security. I mean, sometimes even aspects of this ministry are attached to other ministries, right? So this would not be easy going forward to name such a representative. So if it is that you want someone from the manufacturing sector, then you should in fact say ministry with responsibility for manufacturing. As regards service industries, it would be very difficult to name such a representative either, because there's no one ministry with responsibility for the service industry. When I think of service industry, I really and truly only think of tourism and financial services, which would not be covered by industry and commerce. So that representative, I think, is almost, going forward, could be a dead nail. You wouldn't know who to ask to name this person. So that's just a point I want to make with respect to that position.
My fear, Mr. Simmons, was that if a person, senior officer or employee from the ministry, that particular ministry was to be placed, then they are going to come representing that particular ministry and not this wide cross-section that is being sought. And so the other ministries or industries or sector would be starved of the requisite representation that they are seeking to achieve in this instance. That was my concern with it. Mr. Mahon, you made reference to, again, these various guidelines in relation to the submission of nominees from the respective areas. Listen, it don't make it right, you know. Don't make it right that because you have these guidelines, you actually are to be governed by it. Because what you're saying is that a demand is being made on the organizations to submit a list of nominees to which the preference of a minister will choose from. And so, based on what Senator Brown is suggesting, in a wise institution, I hope you regard one nominee on a piece of submission as a list. Because it is really, and you must give credit to these institutions that when they want to select their representative who are going to be able to serve, they're not somebody who may be even guiding a minister to allow for pecuniary benefit or advantage. Give the benefit to the organizations. And we know how the trade unions operate. So I know you have some guidelines to which would have been developed to cover these scenarios, but as Senator Scarfree in his sort of a comment, they're not duty bound. They should not be. They are guidelines. But the emphasis can be placed in a situation like that for the determination coming from a list. If you don't submit a list, is it going to be rejected? And are you going to call on the institutions to make a list available because those that you don't want, that you're not seeing, is not on that list? These are things that we have to treat with.
Mr. Baker?
Okay, Chair. Just on the point that Mr. Mohan made about 7 and 8, he referred to the document that will give him the authority to select these persons. But I take it wouldn't you want to say in accordance with such and such, because it's going to be subjected to interpretation even after a time. Because it's plainly saying that knowledge and experience in this or in finance.
Chairman, just want to join on the point Mr. Simmons made. What I understand it to be saying in respect to commerce and industry, and let me pause to say agriculture is clearly one of the sectors that would want. It's the largest area of employment. It has a lot of risk involved, so we need to find a way. But what I understand it to be saying, and maybe because the current composition of that ministry include agriculture and fishery, why it is not stated separately. But Mr. Simmons, I can probably here list off all the ministers who have since independence been responsible for areas of commerce, no matter what you call it. I can hear Wills Isaacs, and I tell you him at commerce. I tell you Vivian Blake. I tell you Douglas Vaz. I could go through a list. We have always had it in one form or another. We might not call it industry and commerce. In fact, education has taken over that wing nearest us here. So used to be industry and commerce, way back when, Fenton. It was blue at that time, the glass building where Wills was, right at the end of Duke Street, not Duke Street, East Street. Yeah, that building, that side, that education has now taken it over. But trade and industry, yeah. So essentially that's where we're talking, wherever is dealing with commerce and so forth. So I don't see a problem with that, but given that the current mix may not be perfect, we may not be there forever, the agricultural sector is a sector that I think we should cater for. But of course it can be dealt with by the minister because of the 9 that is specified, it then leaves 6 to be picked. But I hope that agriculture somehow is taken into account because that's where the chemicals are, that's where the risks are. Because we're still at cut machete, right, friends? We're still at machete farming and chopping things. Eh? But I want to see how quick we do that, but we're still there.
Just a quick observation, Chair.
Yes, Member Brown.
We say senior officer or employee. I know the technical people will clean this up, but an employee could be the janitor. So if we want a senior officer, would it just be any employee, or the employee should also be senior to represent? I figure the technical people will clean it up, but it can be, we define, they are essential but not senior.
Yes, Member Skeffrey.
Yeah, that's the point that Senator Brown just made in terms of agriculture and fisheries. I think probably that's where Mr. Simmons was going. Because currently, in agriculture and fishery falls under industrial commerce, agriculture. So that one minister for that broad portfolio. And the explanation we're trying to use agriculture, for example, to justify why you want that particular person. I think I heard it was said that you have issues in agriculture and so on. And that's a dilemma you face when you pick a particular ministry to put in the legislation. So Senator Brown's point is important in terms of number of ministers of industry, but sometimes you don't get the right mix. Because as we speak now, I think agriculture and everything is now as one, and therefore a lot of potential occupational safety and health issues would arise. So if new administration or new changes to the ministry and agriculture is no longer in industry and commerce, then would we seek an amendment to now include them there? So it's how we get the right mix at once, because you have industry and commerce, but as I said, agriculture is now there. But if it's no longer there, and we want that representation on the board, then what do? Although you have room for other appointments nonetheless. But I think that's where Mr. Simmons was trying to the point, and I started to understand where he was going.
Soldier.
Hi, Mr. Chairman and members. Perhaps the issue is how it was crafted, but we don't put the names of ministries in law. What we put are subjects, and the subjects are always, but the subjects are always provided for in the assignment of subjects and departments. All the subjects are provided for, always. So this was not, even if it was crafted that way, it was not an intention. And when it's translated into law, we don't put names of ministries, we put names of subjects. And that's what the Constitution actually talks about, subjects and departments. It doesn't even talk about ministries. But just to point out that if agriculture is to be included, you would have to list it as a subject, because it's not there right now, just on the issue that has come up.
Member Longmore.
Mr. Chairman, I'm a little bit hesitant as I process the request to single out agriculture, whether it is because it falls under the current industry ministry, etc., etc. But we are already faced with a somewhat large board. the predisposition to include in one particular set of employees in this capacity. Construction also is a big group of employees. Healthcare is also a big group of employees. Tourism is also a big group of employees. I think that at this level of the board, we are looking at the persons who will be seen to the thorough, effective, and speedy resolution of whatever issues that may arise. And I think that we should be keeping that as the focus, irrespective of the area of employment or majority thereof. I would not want for us to seem as if we are trying to put a tier system, so to speak, to the level of importance of the potential problems that may arise. And as I said, I am processing the suggestion, but I think that we need to remain focused on the actual purpose of the components of the board.
Senator, and in these committees we try and put forward views. Early in our deliberations, representatives from the agricultural sector came, and we saw how important their intervention was. As a worker representative, internationally, when it comes to health and safety, one of the areas in which a lot of accidents take place is in the agriculture sector. Whether you are in the United Kingdom or Canada and the farm work program and the tractor turnover and kill the Jamaican or chemical, in other words, the workers in agriculture have to interact, and the international agencies that defend workers have all insisted that we must pay special attention because of the nature of the work in agriculture. So it's not about tourism. Smiling without guess may bring you COVID, but it's not about health sector. It's about, well, I did tell you to put smile on the mask front already. You know. But the key thing to me is that this sector, because of its importance to our economy, and we recognize it, the forestry issue and all of those in the bill, somebody from, and I agree with the soldier, the departments, or whatever we call them, the portfolios, the subjects. So for that reason, agriculture ought to have a place in this, and I defend that, and I ask that agriculture have a place in it.
Minister?
We have taken note of all the comments that have been made by the members on the technical teams, and we will raise this with our principals and revert to the committee.
I think you, Mr. Mohan, you had stopped at F. I think we should move to G. I see that the time is, yes, passing by. I don't know if the members, you can advise me, there are just 2 pages, whether we should just yes. So we will take G. We will take G, and depending on the rate of movement, we may ask for the adjournment thereafter. Page 9, general provisions are applicable to the board. Yes, one member has suggested that we take it as read, and if there are any questions, then we will accept the questions now. Yes. Yes, Member Gill.
Start working. Oh, yes. So, G3, the minister may appoint another person to act temporarily in the place of any appointed member who is absent from duty or the island, or who is unable to perform the duties. However, the person selected to act temporarily should be selected in the same manner and from the same category of persons as the person who is unable to act. Now, the first question I want to ask, is this new? Because you have under 9 specifically, a person will be disqualified from being a member of the board in the following circumstances, and it outlines the circumstances, but to attend 3 consecutive meetings of the board without reasonable excuse or explanation, or fails to carry out the functions specified in the act. So, if you are absent with reasonable excuse, and that excuse is accepted by the board, then there would be no need for the minister to appoint a person to act temporarily in the place of somebody who is appointed. I've never seen this yet as a charter for any particular board. If you are being appointed to serve, then you serve, and if you can't serve, then resign. But where you, in the absence of someone, the minister may appoint. And then what if that person that you appoint is someone who is acting better than, or more, provide greater service than? Yeah, take away your space. I know nothing is wrong with it, but I'm dealing with the question of why insert this when if the individual can't serve, then the individual has options that are acceptable in the course of the operations of the board. But I just ask the question, is this new?
Chairman, I've seen it in other legislation. I've seen it in other legislation. And I can envisage, I just beg to disagree with my brother, I can envisage a case where somebody's in a motor vehicle accident, or somebody has gone abroad for treatment, but still interested and has a lot to contribute to the board. And just to keep the board going, I would not be opposed to this clause. I've seen it before in legislation that we have approved, Calvo.
Legal reform or Solgen, any comment? Mrs. Seeley Brown? Could you use your mic?
Seen it too, Chair. Yeah, in the case of, as what Member Brown was saying, somebody travels or, you appoint somebody of the same qualifications to act temporarily in that case.
Question at 12 on page 10. 12 on page 10. Roman 12. Go ahead.
Before we get to page 12, I was just taking it page by page. I don't know if Solicitor General, you have a comment? Yes, 6 is to be adjusted. So the ministry will come back to the committee on it. I just awaiting the surgeon. She seems to have a comment. Yes. Yes.
I'm sorry, Chairman, members. I'm not sure why you would need number 3. Normally, not. For member, yeah, but that's different. It's a commission of parliament. It's not the same. So this is just this is a body corporate. This is not a commission. So my learned friend is pointing out that I'm questioning why we need to have a member of a big board, and when that member is not available, that you need to appoint someone temporarily to act. It's not vital. You need the provision where you have a where it's a chairperson or the deputy, normally we'll put that provision in. And I can understand also for commissions of parliament, and when you have that construct, the construct that is in the Integrity Commission is a construct that's in none of the others, and that's a little different. Outside of that, for bodies corporate, we don't usually put it in, but I'm not saying it can't go in. You can decide whether you want it to be in or not. For the members, for the member, and not the, I can check that.
Mrs. Bennett Campbell? Yes.
Yes, it's not working so well. All right, part of where we looked at it, well, maybe I could read what we were considering so it can be taken. Right, Information, Communication and Technology Authority Act, Schedule 1, number 5, but it says, except in the case of the chairperson, the minister may appoint any person to act temporarily in the place of any appointed member of the board where that appointed member is absent from duty or Jamaica, or B, is unable to perform the duties of the office for any reason. So let me just say where we got it from so it can be considered whether we need it or not. The Information, Communication and Technology Authority Act 2019.
I suggest on this one that we do a little research and come back on it. I have agreed with you all along, my friend.
Yes, Member Longmore.
Yeah. Yes, I think, yes, guided by the research. However, what Mrs. Aldred pointed out in terms of where it usually applies, I think because of the nature of the purpose of this board and recognizing the great need for, again, effective and efficient resolution, if we were to have a situation where critical members were appointed, so let's say the persons that we mentioned before, the Ministry of Health and such representative, the Ministry of Labor representative, etc., who are critical to the process. In that sense, I don't think any meeting should be occurring without their presence. It's almost to the level of the importance of the chairman or the deputy chair. So I don't know if there is some consideration for that in terms of the criticalness of the role of some of these members who would be so appointed.
No. Go ahead.
Yes, you can speak.
No, I'm thinking maybe it was a sign. It is in Jackrow, but I don't like how it is done. For instance, it's just that it should have gone further to explain then if you're going to fill the position, if that person came from, say, the Employers Federation, it has to come from that same body that's missing from Jackrow. That's not what Jackrow says. Jackrow doesn't have it. I'm looking at the provision. It just put in a temporary because they were using a construct. This is why we have to always be careful. When we use a construct, we try to drop it in somewhere and we don't think it through, because it really should have made it clear that if you're going to put it in, whoever appointed that person, that process, that's who should be putting in that temporary appointment, if you really think it's needed. So I think that is how it would. So it's in ICT perhaps because it came from Jackrow. Yes, you'd need that technical expertise to follow through for the temporary appointment. So I mean, I can see the value, but you would need to be very careful about, because you wouldn't want the person who you're filling in for, that person would have had a certain expertise, skill set. And you would be putting in some other person. How would that usually we will say that if you have because I know it's in another law that if you're doing a temporary, no, usually it's where you have a vacancy and you're filling that post. Normally, again, you must fill from the same skill set that you had done for the first one.
Yes, well, I think the last sentence of point 3, I don't know if that would help. or you're saying that, Mrs. Seeley Brown, that we have to go further?
It's usually done for boards where you have persons being appointed who have technical expertise, which is somewhat the case here, but it has to go further to say it must be filled by a person who has the same qualifications as the person who... What it mean? What is temporary? Well, that's the thing.
My comment was I see where it is from the same category, which would be same background, etc., etc. But it's in terms of the technicalities that you mentioned before of whether it ought to be included in this piece of legislation versus another. I am saying that because of the nature of what this legislation is addressed, we need to ensure coverage of the technical skill sets.
Mr. Chair, that's one observation as we analyze it. As the provision is here now, it doesn't stipulate a time frame. So when you say temporarily out, how long is that? So if I go to abroad for a month, the minister may say, boy, I replace Clifford for that month meeting. You still have a quorum. You don't lose your quorum and so on. So yeah, it's very general and unable to perform duties. Over what period of time? So I think we need some time frame here before the minister can trigger that provision if you're gonna keep it. And it relates to 9 as Member Langmore, Senator Langmore is saying. So I think just having it here is loose, and you want to guide the minister. So it's not just to say I'm away for 2 months. You still have a quorum. There are many boards I know have not completed its composition and meeting because you can meet with a quorum, and that's the critical thing going forward. So if you're going to keep this, you have to tidy it up and put a time frame to it in terms of when you can trigger that provision.
Yes, Mrs. Silver.
Vacancies rather than a temporary appointment. So when I use it, it's where a vacancy may occur. For whatever reason, the person may be ill or out of state for a particular period, then you appoint somebody to act in that position temporarily.
Very well. Minister?
I think we have to discuss it further with the legal teams to figure the best way to do it, because it was based on feedback we got while we were putting it in, so we need to discuss it a little more.
I think the suggestion was that further research be done. So we will definitely be doing that, and then now we will revert to the committee. Any other? Yes, member.
Number 9. Number 12. Roman 12. It's there, conflict of interest. But I've seen these provisions written in a way where it is stronger against conflict of interest rather than simply saying you must disclose interest. So I'd like to see the conflict of interest clause in this strengthened to speak to the avoidance of conflict of interest.
Traljan, I would ask you to comment on this. Okay, we're looking at point 12 on page 10, and Member Brown expressed a concern that the conflict of interest clause may not be as strong enough in its current form.
Right, I mean, it's just, they're just putting the basic information down, but we would know, Mrs. Seeley Brown would know how to construct it, and I would know how to review Mrs. Seeley Brown's work.
Well, the language, yes. Yes, so we can now move to page 11. Again, we will take it as read. And we will take the question. Okay, but since we are so close, I'm guided by you, committee. I know it's Okay, all right. Members are saying that we should break now. So we will take the adjournment at this point. Our next meeting is scheduled for the 15th. The 15th?
Yes.
The 15th. I know on the last occasion, members, we had deferred a position on whether or not we'll be having a full day sitting for the subsequent Mondays in June. Yes, for next week we'll do a full day. Certainly, we will advise downstairs so that lunch is prepared. But given where we are and the rate of movement, I implore you that we have a full day meeting the next time. We go until about 4 p.m. Yes, so we'll do 1 hour break between. Yes. Yes, so we'll do it for next week and then we make a determination next week whether we do it for the week after. So there will be no other matter, business for discussion. This meeting is now adjourned until Monday, June 15th at 10 a.m.